Afternoon, ladies and gentlemen. Welcome back to the listening and viewing public, and welcome to those of you who aren't just joining us. This is the continuation of the Joint Select Committee resuming consultations on the Constitution Amendment to the Tobago Self Government Bill and the Tobago Island Government Bill. Ladies and gentlemen, I would like to start again with the committee members introducing themselves, and I'll start with the members in Tobago.
Good afternoon, everyone. Renuka Sagram Singh Suklal, member.
Good afternoon, everyone. Shamfa Kajo, member.
Good afternoon, everyone, and welcome Nigel Freitas, member.
Good afternoon. Welcome Maria Dillon Remy, member.
Good afternoon, Clarence Rambarat, member.
Good afternoon, Rujanat Dar Singh, member.
Good afternoon, Foster Cummings, member.
Good afternoon, Jillian John, member.
Pleasant good afternoon, member Dinesh Rambali.
Thank you very kindly.
What, please? Yeah.
I
Good
understand
afternoon.
we have our members who are not with us in this space, so I can ask those members to introduce themselves also, please.
Sure. Yeah.
Thank you, Madam Chair. Faris Al-Rawi, member.
Thank you, Chair. Dr. Varmadial Singh, member.
Thank you very kindly. And just in case persons don't recognize me, I am the chairman of this Joint Select Committee, Camille Robinson Regis, member and chairman of the Joint Select Committee. I understand we've been joined by stakeholders, and I'd like to ask those stakeholders to introduce themselves, and I welcome them to this consultation. Please introduce yourselves.
Good afternoon, members of the committee. Good afternoon, Trinidad and Tobago. I am Assemblyman Fali Augustine, and I am the team lead for the Progressive Democratic Patriots, the other six in the 6-6 deadlock in Tobago. And with me this afternoon, I have joining from various locations, Assemblyman Dr. Faith B. Israel, Assemblyman Ian Pollard, Assemblyman Pastor Terence Baines, and Assemblyman Zorisha Hackett.
Thank you very kindly, and welcome to all of you who are here with us. I would just like to start with some brief opening remarks. And again, I'd like to welcome all who are here and to thank you very much for joining us, because these consultations are very important. Ladies and gentlemen, the Joint Select Committee of the Parliament of Trinidad and Tobago on the Constitution Amendment Tobago Self Government Bill 2020 is, as I've said before, pleased to resume consultations with Tobago on this important legislative proposal. We remind all that these consultations actually began many years ago. Many of you in Tobago will recall the island-wide consultations and discussions that were held over the period 2014 to 2016. These discussions culminated with a debate in the Tobago House of Assembly, and the output of those discussions and debates was a draft bill to amend the Constitution of the Republic of Trinidad and Tobago to accord self-government to Tobago. This was the genesis of the bill laid in the Parliament of Trinidad and Tobago in 2018. This bill was sent to a Joint Select Committee in March of 2018. Over the period 2018 and 2019, that committee called for comments and submissions and held a series of public hearings with stakeholders and experts from Tobago and Trinidad, as well as legal and other experts with knowledge and experience in relevant constitutional matters from a number of other jurisdictions. The life of that committee ended in 2020. Upon the resumption of the new Parliament, the bill was referred to a new committee in November 2020. This is the committee that is before you. With the aid of the body of research inherited from the last committee, the new Joint Select Committee set about its work. And this committee has since circulated our preliminary findings and proposals. And today we begin receiving your comments. Since this matter is exceedingly important, particularly to our Tobago brothers and sisters, we have begun in Tobago. And we are quite pleased that Tobago is talking. However, we have to talk to each other in our chat rooms as our lives have been changed. And I wish to take this opportunity to thank those of you who have taken the opportunity and the time to come before us. I also wish to remind the people of Trinidad and Tobago of the following. 1, the legislation before the committee is for the autonomy of Tobago. 2, there are 2 draft bills for consideration at this stage. 1 is the bill to amend the Constitution of Trinidad and Tobago, and the second is to provide for operational matters of the Tobago Island government. 3, autonomy is not to be equated with federation. 4, autonomy is not equal to secession or separation. 5, the existing Constitution of Trinidad and Tobago makes Trinidad and Tobago a unitary sovereign state or an archipelagic sovereign state. So let's continue our discussions on the bills before us. So ladies and gentlemen, let's start our discussions. And I invite, is it Mr. Augustine? Assemblyman Augustine, please, you have the floor.
Thank you, Madam Chair. I wish to begin my opening remarks in a way that is very indicative of my Tobagonianness by drawing on an analogy. Because in Tobago, we like to give stories as part of our oral tradition, as a way of explaining what we mean. Trinidad and Tobago is quite like siblings who were bequeathed house and land from a grandparent. So we have this house and land. What has happened since is we have one sibling living upstairs and one sibling living downstairs. Quite a common scenario for Trinidad and Tobago, where sometimes one sibling or one relative will just move downstairs and build out the downstairs and live there. What Tobago has been asking for a very long time is that we be given the permission to, in a very equal fashion, move out of the downstairs and build our own home alongside the existing family home. So that on this vast expanse of property, we will now have 2 homes standing side by side. What we have been demanding for a very long time, if you should trace the history, is that we be given the authority, the autonomy rather, the right to build that house the way we see fit. It may not resemble exactly the original family home. It may not be painted in the same color as the original family home, but we are certain that should we be given this opportunity to build up next door, everyone that passes and look at this vast family property will see 2 siblings thriving side by side. That's what we desire. Having shared that analogy and looking at the object lessons from that and looking at what we desire, I wish to start by, from the get-go, presenting what my team and many Tobagonians that we represent see as our thesis based on what we have read from the last iteration of the last bill that we were given. Bearing in mind, we would have read the 2016 version that was sent down sometime in 2018. In 2018, we saw some changes to that, and now in 2021, we are seeing some additional changes. From our discussions with people over the past few days, because it has just been a few days, we have found that the consensus from the people we represent is that the bill, despite saying that it wishes to amend the constitution to afford Tobago equality in status with Trinidad, in fact, it says equality in status between the island of Tobago and the island of Trinidad, we have found that the mechanisms that were placed within both the constitutional amendments and the Tobago bill does not, in fact, afford such equality in status. In fact, we have found that this bill all but recolonizes Tobago. I wish to share about 5 very broad categories and a list of areas, some examples from the actual bill that I will hope that we can discuss, and that my colleagues who have joined me will help me in deliberating on with you, the committee. Those 5 broad areas which we think that will lead to problems are: 1, we feel that the bill, well, both documents poorly and in some cases wrongly defines Tobago. That's number 1. Number 2, we also feel that there cannot be equality in status when the overreach of the cabinet continues to be as broad or even broader than it is now. Number 3, we found that the bill entrenches a governance structure and model that does not lend itself to full participatory democracy. And in many ways, what we see is an attempt perhaps to mirror some of what we may have in the national parliament, but that does not allow for the kinds of oversight that Tobago wants. And we must bear in mind that the very construct of the THA, with its chief secretary and secretaries, and the fact that we sit around a horseshoe and we have what is called a minority leader as opposed to an opposition leader, is because Tobago from the onset has been deliberate in wanting something that is different and that may at times not even represent Westminster style of governance to its fullest. 4th, we found that the bill also has gone progressively in a retrograde step over between 2016 and 2021. And as a result of these, we find that the ultimate goal, which is to allow Tobago to reach its fullest potential in terms of economic, social, cultural, and so on, that Tobago will not be able to reach its fullest potential. I wish to say, before I begin pointing out the areas of the bill that we will want to have some discussion on, that we get the sense that every time we come about this process, that there is an element of fear in the room. Fear on one side.
Sorry, Mr. Augustine, let me ask, did you have two more points? We got 3 so far.
I identified 1, the cabinet control; 2, the definition of Tobago; 3, the
cabinet control;
3, I looked at democracy and oversight; 4, I looked at the actual structure and model that is placed within the Constitution that will require, that anytime we need amendments, it means that
and what's number 5?
Come back to Trinidad. And the 5th thing I stated is that we have seen clear and progressive but retrograde steps.
All right.
2016 and 2020.
Okay, thanks. So the
And,
first one.
Right. So I pointed, I was at the point of saying that we have recognized that historically, whenever we are this process, there is sometimes that element of fear that should we give Tobago autonomy, it means that we are losing Tobago. And I want to preface our discussion to come by asking that we spend some time looking at the devolution of powers that exist within the United Kingdom and how broad-based they are, especially as it relates to Scotland and Wales. So much so that these territories have the right, if they want, based on the devolution of powers, to secede. But that does not impede them from having a United Kingdom. And so granting Tobago its autonomy does not in any way impede us from having a united Trinidad and Tobago. Having said that, if we look at section 6B, page 3, and we'll be talking immediately about the issue of defining Tobago and what that means, I can let you know that what Tobago sent down the following as the definition of Tobago to be placed in the bill. And let me read that for you verbatim. Tobago sent the following. Tobago shall comprise the island of Tobago, Little Tobago, St. Giles Island, Mab Island, Goat Island, Sisters Island, and other offshore islands and the archipelagic waters lying landward of the established strait baseline, the 12-mile territorial sea measured seaward from the said baselines, as well as the inland waters equidistant between the island of Trinidad and the island of Tobago, and to the extent of the territorial sea of Trinidad and Tobago and the superadjacent airspace above these aforementioned maritime areas and over the land space. Every Tobagonian we speak to feels strongly that Tobago should be defined in that way in the bill. Now, defining Tobago in that way in the bill does not mean that you are going to give the new THA or the Tobago Island government, as it is called in the bill, full legislative jurisdiction over all that I have just said. However, whether it is we are given jurisdiction over 11 miles, 6 miles, or what have you, we feel that that definition of Tobago must be very clear, as I just stated it in the bill. We also find it problematic when we're talking about the definition of Tobago by virtue of where we are seeing our jurisdiction. And you could correct me if I'm wrong, that based on what is present in the pieces of legislation is that basically THA's jurisdiction will now be landlocked, meaning that we're basically just in charge of the land space that is the island of Tobago and just the offshore islands. That poses implications for development of our blue economy. And it means then
Mr.
Augustine?
With this particular point.
So
Thank you, Member Rambarat, please.
Thank you very much, Madam Chair. And Assemblyman Augustine and your team, I'm very happy to be able to engage with you today. I think because I'm the Minister with responsibility for land, I was drawn into your opening and your analogy. And I just want to take you back to your analogy to ask a few questions. But before I do that, the bottom line is that I am still not clear on your 5 points. Point number 4, you refer to model, and I'm still not clear what your model is, what model you propose. You've made reference to the United Kingdom, and you've used in that reference the S word, secession, and you have said that any component of the United Kingdom could secede and they will still remain the United Kingdom. And it caught my attention that you would say that because at this time in the United Kingdom, there is discussions on who wants to exit and who want to reunify. In fact, the Irish are talking about coming back together, and the Scots are looking at being able to stand alone. And in that UK discussion, I never got the impression that in anybody exiting, you end up remaining united. And I don't get the impression that if it is that you're suggesting secession for Tobago, that we could remain a united Trinidad and Tobago. And to use, to me, the best way I could describe my difficulties so far, and I know you'd help me with it, is to go back to the reference that the younger people use, and you are a young man yourself, recently engaged, and I congratulate you. It sounds like it's friends with benefits is the model that you are proposing, and I have grave difficulty in that. So going back to the analogy, I would ask you, on that plot of family land, are you proposing a subdivision? Are you proposing that the subdivision entail the creation of two parcels which are held in separate titles? What exactly is the model that you're proposing? Because we've had references to self-determination, internal self-government, and you have brought the notion of the UK model, as you describe it, using the word secession and proposing that even with secession, you can have unity. And I would suggest that that model is tantamount to friends with benefits. So on your fourth point out of the 5, I would like to know very clearly what model do you propose for the relationship between Trinidad and Tobago?
Madam
Thank
Chair,
you,
I
Member
have a few
Rambarat.
questions for
I'm
Member
going to
Farley.
ask Member Arawi to come in before Assemblyman Augustine speaks. Member Arawi,
Thank
please.
you. Thank you, Madam Chair, and good afternoon to you, Assemblyman, and your team. Thank you so much for coming today to give us your points. I had the same question in a different way that Member Rambarat put, which is, what exactly is the model you are proposing? Because what you have put forward there sounds simple enough, but is dangerously unclear, because you're referring to a precedent of a jurisdiction which in law cannot be treated the way ours is. Let me just ask you, when you're answering Member Rambarat, to also answer the following things, or to tell us your views on this. Number one, the United Kingdom does not have a written constitution, and we do. Number two, the traditional and conventional law from an international law perspective and from a convention law perspective has been settled. So specifically as it relates to the United Nations Convention on the Law of the Sea, the concept of Scotland succeeding, having succession, is not affected by the Convention of the International Law on the Sea, because the convention which existed for 1,000 years prior will prevail. Trinidad and Tobago in the 1986 period entered into certain maritime issues which are critical to Trinidad and Tobago's perspective. So I want you to clarify how you are comparing the English precedent, which does not have a constitution and has conventional rights of over 1,000 years to what you're suggesting to Trinidad and Tobago? And secondly, this is very, very important now. You made reference to the definition of Tobago in the bill as it was proposed. But you said in that it's not as if you're going to ask for legislative power over these waters. You said it was a retrograde step effectively, and that you insisted upon the maritime boundaries being decided and stated. Could you please, therefore, factor in your response the following? Number one, the international law of the sea experts have advised Trinidad and Tobago that because we are a unitary state and an archipelagic state, that the ratios for sea to land between Trinidad and its waters versus Tobago and its waters is almost dramatically half of what it ought to be. In fact, it is 1/3 of what it ought to be. If you treat Tobago and its waters versus Trinidad and its waters, if you treat those two that way, you are going to get 1/3 of the protection for your international maritime boundaries and your exclusive economic zone. When you treat Trinidad and Tobago as an archipelagic state, a unitary state, as one, where Trinidad and its waters are not defined from Tobago and its waters, but you put Trinidad and Tobago, you get 2/3 more. So is it that you are suggesting, is your position on behalf of your party, that Trinidad and Tobago should give up 2/3 of its economic exclusive rights and therefore give away oil and gas and other mining rights to the states of Barbados, Suriname, and Grenada? Is that what you are proposing, that we give up 2/3 of our natural resources?
I thank you for the questions. Can I proceed now to respond?
Please go ahead, and thank you very much, Member Rambarat and Member Arabi. Please go ahead, Assemblyman.
Sure. Now, the point I was making in terms of in relation to drawing a comparison with the devolution of powers that occur within the United Kingdom was not to say that Tobago wants to secede at this time, but was to establish that they are called the United Kingdom, and they have as a policy, written or unwritten, that elements, that parts of that United Kingdom can secede if they so want to. That does not exist in this bill, and we are not saying that it should. But I am making the point very clear that we should not be afraid to accord unto Tobago the kind of broad sweeping autonomy powers that the people of Tobago are seeking, because that in itself does not make us any less united. The only time
can I say that there is no
of each other.
Okay, can I say very clearly that there is no such fear, as you call it? And I think that would be unfortunate if anybody thinks that way. But let me just take a little opportunity now to indicate that with regard to the United Kingdom, as it relates to Scotland, Wales, and Northern Ireland, I'm going to read something for you. The devolved administrations have developed powers over specific matters. The British government exercises reserved powers over all other matters as follows, and the devolved powers are as follows: health and social care, education and training, local government, agriculture, forestry and fisheries, transport, some taxation, justice and policing, some social security elements, sports and the arts, and the areas where there is reserved power that is held by the central government are defense, foreign affairs, immigration, trade policy, constitution, and broadcasting. And let me say, if we look at our 4th and 5th schedule that we have put into the Constitution Amendment, the proposed Constitution Amendment, you would notice that it's very similar to what is here in the United Kingdom that you have been referencing. So please
Madam
go
Chair,
ahead.
Could I please,
yes.
thank you so much for that clarification and on the record. If I could get Mr. Farley, please, while he's clarifying, and thank you for doing so, you started off by saying not being afraid to give Tobago that which it wants. I'd like you, please, in addressing this devolution of powers, to state specifically what you mean, but very importantly, if I could get an immediate answer on, are you telling Tobago and Trinidad to give up 2/3 of their natural resources by defining the waters as you suggest?
Thank you. Well, if I am given the opportunity to finish responding to all the things raised by both yourself, Minister Alwari, and Rambarat, we will get through the very question you're asking again. And I'm happy that Madam Chair read what occurs within the United Kingdom, because you can see that Scotland has some authority when it comes to taxation, for example. So it can raise its own revenue in that regard, which is not afforded to Tobago through what is being proposed right now. We could also see that the kind of autonomy that Scotland and Wales and Northern Ireland has within their arrangement, that is United Kingdom, is far broader than what is being offered to Tobago today through what is being proposed. And the reason why I reference the United Kingdom is because, one, they are part of the Commonwealth and we share similar legal system. Two, we also have developed and evolved from the Westminster politics system as they have. And so it's well worth our while to draw such comparisons. Let me answer Minister Rambarat by indicating that when I say that we want the powers to move out from downstairs and build next door, I am talking about it in a similar fashion to what happens with many families across Trinidad and Tobago. You have a piece of land, at one point you're living downstairs, and the next point you say, look, there is this piece of land out back, I am going to go there and build. Nobody is pulling a fence between the two houses. No one is saying that the fruit trees across both properties cannot be accessed by children from both households. What is simply happening is that we are having two structures side by side. Whether you think that's tongue and country approved or not, that happens in a significant number of cases across this country. And what that analogy points to is what Tobago wants out of this arrangement called Trinidad and Tobago. I will also like to say to Minister Alwari, with the matter of defining Tobago, in 2017, 2018, thereabout, we were invited by the then Chief Secretary, PNM Chief Secretary, that is, Mr. Charles, to sit with a team that included Mr. Hochoy Charles. They call it the Forum of Political Parties, of which we have never been a part of. And in that discussion and in consultations with Tobagonians, because subsequent to that one meeting, we went about collectively, PNM Tobago, PDP Tobago, speaking to Tobagonians about the differences between what we sent down to Trinidad and what we were getting out of the process. And one of the things that came up is the issue of defining Tobago. And it was made very clear that the THA at that time, or previously rather, would have sought legal advice from international legal experts that said contrary to what you are now preferring. And so it's a matter of us having two distinctly different definitions or interpretations rather of what can obtain. In fact, if I go as far as to last year, I saw candidates for your party who are now members of parliament saying on the hustings and saying on interviews that, look, Tobago has to be defined a particular way in this bill. And that is because for us in Tobago, we do not see the same legal challenge as you see. And we do not see that in defining what is Tobago and setting out clearly a policy of responsibility in terms of who will be responsible for what within that area, that somehow will result in us having far less territorial seas accorded unto us. So we do not share that opinion with you. But I'm happy to point out that no, I am not saying that Tobago wants to secede. That is not what Tobago wants at this time. What Tobago wants is its autonomy. And what Tobago is saying to our colleagues and friends and family in Trinidad is that having this, giving us the autonomy as we desire it, does not in any way lead to a fracturing of the union that is Trinidad and Tobago. Notwithstanding historically, this union was a forced marriage. We do not believe that by according to Tobago, the kind of autonomy that we propose, that we desire, that we have been clamoring for since James begat, through A. P.T. James, through Robinson and Winston Murray, all the way to this present moment, that autonomy in no way jeopardizes the union that is Trinidad and Tobago. And so there is no need to be fearful of giving Tobago the autonomy that it seeks. And that's where we have some differences in opinion in terms of defining Tobago and why that should be part of the legislation. Now, moving to the other areas, I want to bring in at this time Dr. Faith B. Israel. And Dr. Faith B. Israel will be looking at section 11(1), page 6, as we look at the issue of cabinet control in emergencies or unforeseen circumstances and the implications of that based on how it is written. And
Madam Chair,
let me just say, just a minute, Member
Sorry, Madam Chair.
I just want to make the point again that the advice of the constitutional experts upon which we relied was that it is not advisable and it is impractical to divide the waters of a unitary state. The AG has said this, and the practice in international law does not support this. Let me also say, just to amplify what I've just said, is that archipelagic states do not divide the waters between their regions or their islands. And the AG has talked about the 1/3 and the 2/3. So I just thought that I'd make that point again. And AG, please go ahead.
Thank you so much. Thank you, Member Augustine, for your response. Could I please ask, so that we have a confirmation of your position, you indicated that you do not agree with the advice given to you. Would you be so kind as to share the legal advice upon which you have based your statement, that you effectively are saying that your party supports defining maritime boundary? In the caution that I have offered, I have said that the international law experts on the law of the sea have said to us that it is dangerous and retrograde to Trinidad and Tobago's well-being, particularly in its economic exclusive zones, to seek to define the waters of Trinidad versus the waters of Tobago. So would you be so kind as to provide us, after this meeting, your legal advice in relation to this submission, because this is a very core submission, which we would like to be able to reflect upon so that we can address your issues in a very fulsome way. Thank you so much. I believe you're moving on to Member Israel.
And yes, just before I move on to Dr. Israel, I will indicate that that advice was brought to the Tobago House of Assembly as a whole, and I will have that advice from the Tobago House of Assembly be forwarded to you. And I will also put a plug to say that the leadership for that advice came not from the PDP, but actually came from members of your own party that led Tobago at that time. And
if that's the case, we have that advice.
Additionally, though, if it is you're saying that we do not want to define Tobago in the bill, may I ask what then prevents us from within this bill saying, well, okay, then Tobago, you have jurisdiction to make laws for all of those areas, without saying Tobago, that belongs to you, that is Tobago. What prevents us from saying, just simply saying, Tobago, your jurisdiction, your legal jurisdiction, you can seek to develop or to explore all that is within that which I just read as that definition of Tobago?
May I, Madam Chair? Thank you, Member Augustine. Just to say this, we are talking about the Constitution of the Republic of Trinidad and Tobago. So we have two bills before us. We're talking about defining the maritime boundary of Tobago in the Constitution of the Republic of Trinidad and Tobago, not in an act of parliament, but in the Constitution. The consequence of defining the waters of Tobago by itself is that the law of the sea and then our economic exclusive zones from an archipelagic law perspective, the advice that we receive from international experts is that you will be giving up effectively 2/3, I'm putting this in my own words, 2/3 of your economic zone. So all of your oil and gas rights, that would be 2/3 more outside of where you are because of the ratios that the law of the sea operates on, you'd be giving that up. So the caution here is that in the Constitution Amendment Bill, the advice is do not amend the Constitution to define the waters of Trinidad versus the waters of Tobago, because you will reduce yourself in the margins and the ratios, and you'll be giving up against other territories, in particular, those to the north and to the south of us, Barbados, Grenada, Suriname, Guyana. You'd be giving up rights that you're entitled to. I should point out as well.
Can I ask you a question, Minister Alwari?
Sure.
The question is, did the previous 6 months, because prior to these two pieces of legislation that we are now discussing,
I was going to come to that.
Did that affect us and our right to our EEZ?
That's an excellent question, member. You've hit the nail on the head. I was just about to come to that. I started with the Constitution bill. The other bill is comparable to the THA Act. In the THA Act, there was the 6 mile reference. The international law experts have pointed out that that THA 6 mile has never been operationalized. And in fact, the submission in law is that it cannot be operationalized, that it is effectively useless. But in any event, the legal opinion is that that is a subsidiary law to the Constitution. The problem that we get into is amending the Constitution. If we're going to define the waters of Tobago, and you have to define the waters of Trinidad, you're going to give up your economic zone. To answer your question now, or parts of your economic zone. To answer your question, the reference in the THA Act to the 6 mile, even though it was there, the written opinion that we have, which is part of the committee's documents and which will become public, is that that law is unworkable. What we did is we went to the models that exist in the CARICOM, St. Kitts and Nevis, etc., and we relied upon just the definition of the island of Tobago as it has been put forward, and the island of Trinidad will obviously be the same, but we're not touching the maritime issues. One last point. We are currently engaged in discussions at an international law level in our oil and gas scenario in particular, where we are defining what our economic zones will include in terms of oil and gas. we are dealing with our shipping laws and our maritime laws at the same point in time. So at this moment in time, we are in a dangerous state of flux as a country, the Republic of Trinidad and Tobago. And the advice that has come to Trinidad and Tobago is do not touch your maritime boundaries in your constitution. And if you're looking to the comparator of the THA's Act reference to the 6 miles, the advice is that that was unworkable in law and should be abandoned.
Sorry to belabor this issue, because now we are raising several other issues. And one of the reasons why Tobagonians far and wide, whether they support my party or not, are very resolute and very unwavering in their position in terms of defining what is Tobago, is that we are afraid of being pigeonholed when it comes to our ability to grow economically. And if that's one of the goals of giving Tobago its autonomy, so that Tobago, as a contributor to the nation that is Trinidad and Tobago, can grow and arrive at a place where comparatively we are similar, we are even playing field with our brothers and sisters in Trinidad, then we will have to have some ability to be able to explore for economic reasons that which exists in the maritime waters surrounding Tobago. And let me give you a very simple example. I represent the district of Palo-Tuvier, Lansom, Speyside. In the year 2011, we were told by the THA, 2011, I did not even dream of a career in politics then. We were told by the then THA, we will create a marine park for Speyside. The THA had no authority to do so, notwithstanding the THA Act of 1996, giving us control over six miles of water. We could not, and that's something that required action from the central government. The very last act of the last THA is when we unanimously passed a marine bill so that we can create a marine park down at the Buku area. And we have found from our experiences that something as simple as a marine park, which fits in tandem with our economic and our sustainable goals and our economic plans and our tourism plans, because Tobago has always pitched itself as being safe and green and clean and serene and so forth. We could not, because we just did not have the autonomy to do so. And one of the reasons why we are adamant about this point is because we want a THA that has the authority, if it needs to protect the marine life in Speyside, where I live, where I grew up, that I see every day, where we experiencing coral bleaching and almost the death of the largest brain coral in the Western Hemisphere. The THA must be able to do so without having to curtsy and beg someone at the National Parliament to make this a priority, when it may just not be a national priority for any ministry at all. And that's why Tobagonians like myself will have a fundamental difference in opinion and a fundamental problem with the bill as it is so written. And I feel the need to put that on the table so you understand where I am coming from and know that this is not just PDP being facetious, but
okay, no, we don't think so.
Right. Madam Chair,
we don't think so. Attorney General, perhaps you can assist by indicating whether or not this bill that's before us will prevent that from taking place.
Sure, Madam Chair.
Because that is a definite point, and perhaps you can assist us in this way.
Madam Chair, thank you, and thank you, Member Mr. Augustine Farley, for a very good example. First of all, the entire THA, including the representatives other than the PDP, sent the Marine Park Bill to the Parliament under the process of a Tobago Bill, which is what the current law provides. That therefore means that you are not alone in your desire to see Tobago have its legislative powers. All of the representatives of the House of Assembly in its last form were in that same position. Secondly, the good news is that the Marine Park Bill would be of the very type of bill that Tobago could have involvement in, if not full autonomy in, by the structures that we are treating with here. The statement of the question is this, if I put it very simply, does an absence of 6 miles in the maritime boundary prohibit Tobago from passing a law which treats with Tobago waters or waters in or around Tobago? And the answer to that is that it depends upon the cases. So it is a fact-specific circumstance. What we are giving now in this constitutional amendment bill and the companion bill is the authority for Tobago to enter into its structures of legislative reform. The international advice that we have received on the law of the sea specifically is that if Tobago were to have the maritime boundary stated, Tobago will get by far less than it deserves, and worse yet, Trinidad and Tobago will probably lose about 2/3 of its structure. That comes from the specific advice. I should just put for the record, it is Ambassador Extraordinary and Plenipotentiary Gerald Thompson. We also had advice coming from a member who sat on the law of the sea of the United Nations, retired Mr. Justice of Appeal Lucky. The ratios that they are referring to in that particular context are what is very, very important for us to have knowledge of. And they specifically relate to revenue sharing. Revenue sharing, as Mr. Augustine has put out, is exactly contemplated in this legislation and in the Constitution. The ability to have revenue attributed directly to Tobago and to have control, all of that is inside of the particular structures. So we are very much on the same page. What this legislation does, the draft bills before us, is that it gives Tobago more rather than less. If you were to insist upon, if we as a group were to insist upon defining waters, we'd be giving up much more than we are getting.
Madam Chair.
Member Kajo, you've been wanting to make a point.
Yes, I've been wanting to make a point.
Member De Freitas.
Yes, Madam Chair, like Mr. Augustine said, any Tobagonian from any side of the divide is very, very passionate about this issue as it relates to the miles and the boundaries and so on. And I think it takes nothing from us to share the advice that we were given and to ventilate this matter a little more, if not here, at some other time. Maybe tomorrow we could come prepared to explore that matter, because I know that both the Tobago House of Assembly in sending its position to us would have gotten legal advice also, and as the Attorney General has just stated, the legal advice that was available to us here at the Joint Select Committee, I think that Tobagonians would feel unsettled in moving forward if they are not able to fully capture and understand all that is before us. So I really think that this is a matter that needs to be ventilated, or the information needs to be shared also, because this is near and dear to the heart of the Tobagonian. I know today is not my time to talk, but I just felt the need to make that interjection there.
Let me just say that this is a discussion, it's a conversation that we're having so that we can ensure that we ventilate all the issues. Member De Freitas.
Thank you, Madam Chair. So I've been listening to what the Attorney General has been saying, and I've also been listening to what Mr. Augustine has been saying, and I just want to ask from the standpoint of the Attorney General. So as much as I understand the implications of having the maritime boundaries set out in the Constitution for us internationally, what I'm asking is that I've seen suggestions elsewhere in other learnings that a sort of domestic-only arrangement can be come up with between Trinidad and Tobago in relation to boundaries by way of nautical miles. And one of the arguments that was put forward in relation to that as a benefit was that it would not interfere with any of the international implications that the AG was suggesting would happen if we were to put it in the Constitution, because that particular arrangement is only between Trinidad and only between Tobago and has no weight internationally, because any implication internationally would only recognize the unitary state of Trinidad and Tobago. AG, is that something that is possible, or is it not possible at all?
Madam Chair, I thank the member for the question. That goes to the root of the caution coming from Ambassador Thompson that the very reference to 6 miles in the THA Act is unworkable, if not wrong in law. It's not the first time that we've seen things unworkable in the original THA structures. For example, the impasse which has not allowed us to constitute in full form the full assembly is a very real example of the THA Act in its original form not going as far or as sensibly as it ought to, and why we must review it. So my short answer to that is it's probably not going to happen. It's traversed in the advice of Thompson. That advice tells us that the reference to the 6 miles is something that ought not to have happened in the THA Act and cannot be implemented. That is not to say, and this is very important, that Tobago cannot deal with its marine parks. In fact, that marine park bill is near completion in terms of the workings that we have to do. And that will certainly be something that will be returning to the forefront very shortly.
Madam
AG,
Chair.
just one question, Assemblyman, before you come in. Let me just ask the AG. AG, perhaps then for specificity, something like that, we can do an amendment to the 4th schedule and the 5th schedule, where we talk about parks. We have in the 4th schedule, we have lawmaking powers in relation to parks and other places for public recreation. Perhaps we could include a phrase like marine parks. You know, that may help. If we said marine parks, parks and other places for public recreation, so that concern would be alleviated. And then in the areas of exclusive executive or administrative powers, we can specifically talk about marine areas and so on. Is that possible,
Yes,
AG?
Madam Chair, we can certainly look at the marine parks aspect. The only caution right now, and understand this is just a temporary situation, because the fisheries aspect and the law of the sea aspects are ongoing products right now. We're not quite on firm, dried concrete yet. And there are some large moving parts that we have to comply with when we deal with Minister Rambarat is the person with responsibility on these ends, and he can confirm what I'm saying. We are in a joint select committee right now with the Shipping Act, Shipping Act, Shipping Bill, and that has a lot of moving parts with international conventions that we are bound to deal with, lest we have a sinking of our industry. And I would just caution that until we finish that bill in particular, the shipping bill, we ought to be extremely circumspect about this until that is finished.
Chair?
Member? Madam Chair?
Previously, and it's being raised again, but it's something that we can undertake to look at. Member Assemblyman Augustine, please go ahead.
Yes, and I'm glad you asked that question, because if we should look at what is within the 5th schedule versus the 4th schedule, we will see fisheries in the 5th schedule. So if what we have now is to be passed as is, it will mean that we will have a THA with so-called more autonomy that will still have to revert to the central government in Trinidad to be able to do something as simple as a marine park. Even if we decide subsequent to the passing of this law, we want to go clean with fuel and we want to put up some windmills in the Atlantic, we have to wait on the central government to decide whether we can or cannot. And for many Tobagonians looking on, we find it somewhat unfair that we are being told, look, we can't just yet decide whether we could give you some of these authority, because one, we have one advice that cautions, one, not multiple, but one advice that cautions. And two, right now we are doing something with the Shipping Act to ensure we fix our shipping industry and so on. And so Tobago, you must wait on this matter. The point of autonomy is that Tobago should be able to say, if it wants to carve out a slightly different economic trajectory to that of neighboring Trinidad, that it has the autonomy so to do. That's the point of autonomy. So we can't give it with one hand and take it back from the other, but I expect us to have many, many more discussions on this. I can tell you, Madam Chair, that we are going to embark on public meetings and discussions on the matter, because you will appreciate that the bill only got to us sometime last weekend, thereabout, and I'm certain that this is one of the matters that Tobagonians will be raising over and over again. So expect it to keep coming up until we find a suitable middle ground with this on this matter.
Madam Chair, I don't want to interrupt unnecessarily, but just to correct something that the Honorable Assemblyman has put on the record. This is not a simple matter. It's not just let's sort out the shipping bill so that we could sort out our shipping industry. That's not what it is. We have international conventions that we are bound to obey as a Republic of Trinidad and Tobago, number one. Number two, the example of putting up clean energy windmills in the Atlantic sounds great, but that is under the Paris Accord clean energy arrangements, which is again international law. And then when you actually filter what Assemblyman has said, the power purchase arrangements and feed-in tariffs and TNTech administration, these are aspects shared between Trinidad and Tobago. So I want to caution against discounting very serious matters in a very quick pass sort of way. We are not going to do justice. Real autonomy means having autonomy to do things which we ought to do and which will be prudent for all of us. So saying, put in the Constitution, the waters of Tobago by reference to miles on the record as a matter of international law, we will be giving up a massive amount of economic potential on an idea without paying attention to the details. So I want to be very cautious about using simple examples for complicated matters. We have to be sure that what we're doing is doing the right thing with the best interest. And what I'm saying about the shipping bill is that this is no small matter. This is a very large matter. Look at the attention it occupied in the Brexit discussion. It wasn't, well, yeah, we're all fishing. It was, what are the ramifications to the economic outturn of the European Union versus the United Kingdom and Ireland when you looked at them seeing it, not Northern Ireland, into the European Union. So these are not simple matters to be easily put aside by a label of saying, well, it's just that. So just the final points I wanted to make. I believe Member Dillon has been trying to make a point.
Member Dillon, please.
Thank you, Madam Chair. I just wanted to ask whether we can take Assemblyman Augustine's point about the ability for Tobago to do what is required for Tobago's development as it relates to Tobago's, as he said, we're surrounded by seas or Tobago's lifeline, etc. And once that is taken into consideration, then whatever, in other words, as he said also, the discussion can go on as to what is necessary to find a meaningful middle ground. And I think that should be taken because it's so important.
Chairman.
Member Dylan Remy, I did say that,
okay,
that we would take that point because I think it's important for Tobagonians to get the understanding and the feeling that this is what we are attempting to do. And let me just make the other point that we have stated in Schedule 4, the fourth schedule, that the manufacture and supply of electricity is one of the areas over which the Tobago Island government will have, the Tobago Island legislature will have legislative and exclusive lawmaking powers. So that issue of windmills and so on for clean energy, that certainly falls under the manufacture and supply of electricity. But so we have said, and I have said on behalf of the committee, that that will be taken on board. Member Kajo, you wanted to say something?
Chairman, I just wanted to support what Senator Remy was saying, and to add that it may not, that it shouldn't just be marine parks or this marine electricity that you're talking about. There may be other marine-related economic activity that has to be captured here. So again, I want to press that this needs to be explored, ventilated, and shared so we could come to an acceptable point.
Yes, as I said, this is a committee that will take those things on board, and we will make sure that we do what is best for us to move this process forward. If none of the committee members have anything else to say, I think Assemblyman Faith Israel was going to make a point at this point. This is her opportunity to intervene.
Please will enter and speak to section 11, 1B, that's on page 6. And we will then go back to the lawmaking powers in the fourth schedule versus the executive administrative powers in fifth schedule subsequent to that. So over to Dr. Faith B. Israel.
Thank you,
Dr.
Assemblyman.
Israel, you have the floor.
Thank you, Assemblyman Farley. Thank you to the committee. Thanks to the chair. I think I would like to take this opportunity to, in addition to speak about that specific issue, which is cabinet control in circumstances when we have emergency and unforeseen circumstances, because we are kind of running into almost close to the 3 o'clock hour. I would like to lump in that category. There is a general concern of the people of Tobago that we have cabinet control in areas where we should not have cabinet control. And this is one of those areas where we seem to have cabinet control in areas where we have, in situations where we have emergencies and unforeseen circumstances. And we do not have a clear definition of what entails an emergency or what really entails an unforeseen circumstance. And it seems like the definition of those things may be at the whim and or fancy of the cabinet. And we would then just have to comply with the situation in that circumstance. And let me
That's a good point. That's a good point. Thank you very much. We will take that on board.
And may I also throw in 2 other areas where cabinet control is simply not acceptable to the people of Tobago. And those areas include the Mediation Committee and the Fiscal Review Commission. And let me give you an example. For both of those, we have the situation where the chair of the committee is going to be a member of the cabinet. Those 2 committees both have 5 individuals. 3 of those individuals will come from the cabinet, and 2 of those individuals would come from the Tobago House of Assembly. Specifically as it relates to the Mediation Committee, we understand that the only time we may actually get to mediation, and we are seeing the situation right now, even with the 6-6 situation in Tobago, that to need mediation, it means that the 2 parties are not able to come to an agreement among themselves. And therefore, in the old Tobago House of Assembly, there was a dispute resolution commission that was in essence an independent entity that had individuals who were agreed upon by both parties, but did not include the both parties themselves. So we are recommending that that mediation committee look more closely like what was in the Dispute Resolution Committee and not be headed and outnumbered by the cabinet. And a similar thing needs to be looked at for the Fiscal Review Commission, because if we are looking at a situation where the cabinet has 3 of the 5 members and the cabinet is in control, as in chair, those committees, then we are automatically seeing where it is not equitable distribution, it is not equitable control within the committees. So we need to review the composition of both of those that committee and commission respectively.
Okay, thank you. We will do that. Thank you very much.
Then
Assemblyman Augustine, you have any more interventions? Thank you very much, Assemblyman Israel.
Then we want to move specifically to the areas listed under the 4th schedule versus the 5th schedule, and we will do a juxtaposition with the Act 40 of 1996's 5th schedule, which had 33 items listed there. We note, even from the discussions this morning, the differentiation between Schedule 4, which gives authority to make laws for, versus Schedule 5, which gives administrative authority for, and the differences in those. And Assemblyman Ian Pollard from Providence, Mason and Moriah will speak to these issues now.
Thank you, Assemblyman Pollard. You have the floor. Assemblyman Pollard, you have the floor.
Good afternoon, Madam Chair.
Good afternoon.
To your entire committee and the rest of Tobago watching on. Now, I took note of items under the 5th schedule in the Act 40 of 1996, where there were 33 items listed that the Tobago House of Assembly had purview over. And I've seen that it has been separated into the 4th and 5th schedule. But most noteworthy that has been removed, or maybe the AG could explain, because I could remember him distinctly in 2015, first at our meeting here in Mason about one, the land regularization for Tobagonians. That will be a thing of the past. And secondly, I'm seeing here in the 5th schedule of the Act 40 of 1996, state lands was under the purview of the Tobago House of Assembly. And under the 5th schedule of this new bill, this draft administration bill, we are seeing lands and building other than lands and building vested in the state. With a little bit of, I will need a little bit of clarity, is that the state land has been removed from under the Tobago House of Assembly to the central government, because it's clearly not identified that it was, as it was in Act 40 of 1996. And there are many other items that we're not seeing there, such as telecommunication, custom and excise. So is it that it's a good thing this is a draft that we have discussions about it? But so could the AG clarify the points of why these items have been removed from under Act 40 of 1996 in this present draft bill?
Madam Chair, may I?
Go ahead, please.
Madam Chair, what would be very useful, well, it wasn't the AG that advised on the 5th schedule at all, it's the work of the committee. So what would be extremely useful is if that list of what is observed inconsistencies between 5th schedule and THA's act was provided to us. And I think that the committee should look at those matters, certainly, so that we can make sure that we are in harmony with, at the very least, what we had in the THA Act versus what the proposed bill makes. Is that agreeable?
Yes.
Thank you.
Madam Chair, I believe Assemblyman Zorisha Hackett wants to come in at this juncture
So you will
speak additionally.
Sorry, just to reiterate what the AG said, you will send the list. You can send the list to the committee Or are you saying that you're using the list that is in the current THA Act? That's what you're saying?
Well, you're just in, Madam Chair.
I'm asking the list
Madam
that is
Chair,
now. Yes.
Sorry, I'm asking.
I think I did not hear.
I'm asking specifically if Mr. Assemblyman Pollard could kindly send us the list of his observed inconsistencies so that we have the opportunity to check it carefully so that we can make sure that we are proper and whole with what was there. And if there are any differences, that we can provide an explanation in respect of it.
Okay, so just to repeat that you're asking Assemblyman to send Pollard to send the list of inconsistencies.
So, Madam Chair, whatever his observations are, he was reading from a list. That list says we have spotted inconsistencies. I want to make sure that we are faithful to his observations. So if he provides us with the material that he has, we could then see exactly what it is he's saying, and we can compare it as a committee.
All right, thanks very much.
Madam Chair, to the AG, I was reading from the Act 40 of 1996. So it's all listed inside there.
All right. Well, we have it. Thank you very much.
But Madam Chair, I know Assemblyman Hackett wants to come in to develop what Pollard has been raising some more. But for us in Tobago, we feel areas like environment, forestry, that all of those should remain under the remit of the THA. And we will send you a detailed listing in terms of, as the AG suggested, of how we believe they should be proportioned between the 4th schedule and the 5th schedule in the new proposed bill. But I will want Ms. Hackett to come in and expand some more on why we are having some difficulties with the limitations set out within the 4th schedule, notwithstanding the fact that you and many others see that as some gains over what you have had. So maybe Ms. Hackett can come in at this time.
Certainly, Ms. Hackett. Assemblyman Hackett, you have the floor.
Good afternoon, all. Are you all hearing me?
Yes, we are.
All right, so please permit me a moment to begin by reminding all that historically Tobago was a constitutionally superior island. As the annals of history would show, Tobago holding its inaugural session and at its earlier version of the Tobago House of Assembly all the way back in 1768, at which point Trinidad was still a Spanish colony. It would be a further 28 years before Trinidad finally became under British control, whereupon it was treated as a conquered colony and governed under Crown colony rule. As we are all aware, the downgrading of this island's constitutional status at the end of the 19th century was closely linked to a downturn in its economic fortunes, creating a current constitutional subordination, as I like to call it, to Trinidad. And so in this 137 years since 1884, Tobago has been constantly seeking self-determination and freedom through economic development and representative government. And since 1889, within the framework of the nation state of Trinidad and Tobago, Tobago has been searching for equality of status and avoidance of economic dependence on Trinidad. And these bills that we have in front of us, Madam Chair, in my opinion, are a far cry as they deny the quest and to some extent our right to determine in Tobago our political, economic, social, and cultural development, and further reinforces our economic dependence on Trinidad by denying us the adequate access to development opportunity. So right now, let me just look at the comparisons between 4th and 5th. Correct. The bill assigns the THA prescribed schedule of responsibilities. Fourth schedule, lawmaking, and fifth schedule, administrative responsibilities for laws made by Trinidad. All reserved powers are left to Trinidad and disguised to me as Trinidad and Tobago. A critical observation that is relevant here is that the fifth schedule leaves all the policy and lawmaking responsibilities to key areas, as we would have already established, and the push for economic, social, and institutional development, and for which it must be able to make policy and law. And I can state them: education, health, tourism, sports, planning and development, as well as works and infrastructure. In my opinion, this is the opposite of what is required, and Tobago must prescribe what it wants a central government to do to facilitate this development. Thus, it is the central government that should be assigned the prescribed responsibilities. Can I have some clarification here, please?
Madam Chair, could I just ask a question? To Ms. Hackett, Assemblywoman Hackett.
Yes, sir.
Who makes up the central government?
Members of constituencies.
Is Tobago included in that?
Yes, sir. But what is the proportion, sir?
Right. So what I'm saying is that I keep hearing references to central government, parliament, and as though Trinidad and Tobago, or the Parliament of Trinidad and Tobago's central government, is just Trinidad. It's not. There's a unitary state of Trinidad and Tobago. Regardless of the proportion, yes, we understand that could be discussed at a later date, but that has nothing to do with the bills. Trinidad and Tobago, by way of its parliament, has representation on behalf of Tobago. Same thing with the central government. So when you are saying the central government can't do this and can't do that, what you're actually saying is that the representation that Tobago has there.
I didn't say the central government can't do, though. I think you misquoted me there, but continue.
No, go ahead. Go ahead. You were saying.
No, continue.
No, because that is the general gist of what I am hearing. Let me not speak for anybody else. In that, when you refer to central government, you're referring to only Trinidad. And that's not the case. The Tobago is also part of that.
Madam Chair, if I may do an interjection here and point out that culturally and based on our experience, the majority of Tobagonians, the vast majority of Tobagonians, view what happens at the central government as Trinidad and not as Trinidad and Tobago. So let us not pretend at this session that Tobagonians view the central government any different. And that is so based on our experiences. When we take, for example,
Member Assemblyman, I'm sorry that is how you think the feeling is, but that is not the fact. The thing is that the central government is the government of Trinidad and Tobago. The parliament, similarly, is the parliament of the Republic of Trinidad and Tobago. The judiciary is the judiciary of Trinidad and Tobago. Those are the three arms of the government of Trinidad and Tobago, and all are for the governance of Trinidad and Tobago under the Constitution. What we're trying to do is ensure that Tobago gets the level of autonomy that they are in search of for many years. And this is what we're trying to discuss. I'm sorry if there are those feelings, but the reality is that central government is for the Republic of Trinidad and Tobago. And what the legislation, both pieces are attempting to do is to ensure that we carve out for Tobago even more autonomy than they have now.
Well, Madam Chair, if you'd allow me to finish, I would have shown where the reality of how governance has been practiced historically in this country has not always led Tobagonians to that feeling of comfort that you would hope that we will have from seeing this bill. And it's a matter of comfort and trust. And that's just the reality. And that's not going to change just so. That will require some work, and it will require that we craft the legislation in such a way to bring the kind of comfort that is required. And that's why we have said that we will send to you that list in terms of 4th versus 5th schedule, and how we believe, based on our consultations with the people we represent in Tobago, how we feel that should be proportioned, and the committee can look at that subsequently.
We look forward to receiving that.
Madam Chair.
Thank you very much. Member Cummings.
Thank you, Madam Chair. Can I also ask Assemblyman Augustine if, in submitting that list in relation to the 4th and 5th schedule, whether that matter concerning the definition of Tobago, which occupied so much of our time, and which a couple of members may have indicated that we should find a way to agree on some middle ground, whether you would want to also submit your suggestions in that regard in terms of the economic benefits of Tobago that you outlined, and how the definition, as you have suggested, would work towards that goal. If you would submit that as
Or most definitely, we will be happy to make that submission, because we think it is critical. If one of the stated goals in the actual legislation is so that we could allow for Tobago to grow in terms of the economy, culturally, socially, and so on, then it's paramount that the legislation allows for that to actually happen. And we believe that that definition of Tobago and how it is pitched in the law will either allow for that to happen or will stymie the very sustainable growth that we seek. Madam Chair, I want to bring in at this juncture Assemblyman Pastor Terence Baines. And he has a few questions asked. And additionally, we have some general issues that we will raise before we conclude. We are mindful that we did start a bit late, 1:25, so we started 25 minutes late. And I don't know if we will be rushed to close, notwithstanding the late start, but we will appreciate if, for the very least, we allow a few more minutes beyond the 3 p.m. deadline so that we can do the wrap up on some of the general issues to be brought before the committee.
Before you do that, I remember you had made your point 4 was with regard to parliamentary oversight. Could you expand a bit on that, please? Because we'd like to hear a little more about that.
Sure, and I'll do that before Pastor Baines comes in. In the legislation as is being proposed, we have oversight by way of House committees. And we have a structure being proposed where, by one, there is no limit on how large the executive can be. So for all intents and purpose, out of a house where there out of the entire house, we could have literally 16 members of an executive, because there isn't any limit within the actual law that's there. It means then that the remaining members that are present within the House to help form out and lead on those House committees, that number is decreased significantly. We also have been wondering, so that's one aspect in terms of oversight. The second aspect is that we have been wondering, what was proposed was a bicameral system, and we have moved to a unicameral system. That's all well and good. Did the committee consider at any point delinking the House from the executive and having a system of separation of powers to create the kind of robust oversight and accountability that we believe Tobago wants? That might be a deviation from the Westminster model and a deviation from what we know, but will create that kind of oversight, because the idea behind having the dual houses, what was sent down was called the People's House, and the idea behind the People's House was to have a secondary house with the role of taking up most of those oversight functions in a much more robust manner than just having house committees. So that's the second thing. And the third area is, was there any consideration given to the issue of how we could involve e-governance in all of this so that will maximize people participation within the democracy? I have been to jurisdictions within the Commonwealth where they have systems in place where people can petition their government, where people can force their parliament to discuss certain issues and bills and answer questions. And I feel like if we are having the opportunity to create something new for Tobago, then it's an opportunity to do it in such a manner that it allows for the kind of far-reaching and robust oversight and active participation from as wide a populace as possible, so that we could begin, if it were, an example for the rest of the country to follow.
That those were not the instructions that came to this Joint Select Committee from the bill that was sent to the cabinet. In addition to that, there is nothing that would prevent, when this system has been established, there's nothing that will prevent the legislature using the government's policy from doing that, putting in an e-government system, putting in all those systems that you may be talking about. It doesn't mean that all of those specifics have to be within the Constitution Amendment or have to be in the Tobago Island government bills that will be passed by the Parliament. But it will not preclude that from happening thereafter.
However, if it's not codified in law, it means that it is up to the whims and fancy of whoever is in charge of the executive.
Remember?
No, Madam Chair, let me just...
Remember what happens with the 4th and 5th schedule. With the 4th schedule, a law of that nature could be made by the Tobago legislature. Remember, the Tobago legislature will have lawmaking power over the island of Tobago. So if that is something that needs to be done, you know, that would be a policy decision, and it could be done depending on how you want something to proceed.
But Madam Chair, I'm not sure.
Member De Freitas, you wanted to say something?
Yes, Madam Chair. Sorry, Assemblyman Augustine, is just to add to what Madam Chair is saying. But subsequent to the build-out of the proposed Tobago House of Assembly legislature, standing orders of the legislature would need to be done. And within those standing orders, you can incorporate provisions amongst the assemblymen, obviously assemblymen and assemblywomen, provisions that allow for more participatory democracy. One way of doing that is, for example, what we have in the National Parliament, which is the Private Members' Day, which essentially is individuals who do not hold executive positions. So in the context of the Tobago legislature as proposed, you would have the independent councillors and the opposition members, obviously, and any other members who don't hold a portfolio. It is through lobbying of those individuals that members of the public could have a particular topic raised in the Assembly legislature that would come up on that Private Members' Day for discussion. I'm not saying you have to follow that exactly. What I'm really saying is that as you develop your standing orders, you can create, something within there that allows for more participatory democracy by the public in relation to that. In relation to your statements with the Joint Select Committees, the executive members do not limit how the Joint Select Committees work, because you could have executive members on Joint Select Committees. I think what you're referring to more is how these Joint Select Committees are chaired. In the National Parliament context, we have independent senators that chair certain committees. We have opposition members, and we have it in this bill, that are going to be chairing the PAC and the PAAC, because that is the oversight mechanism that is put in there. And then, depending on how the legislature sets up itself, you would have other Joint Select Committees as is needed in relation to have the kind of proper oversight of the executive. And of course, the chairmanship of those will come into question at that point in time. But the fact is, 26 members of a total legislature, you can set up a joint select committees as long, the only stipulation is that it mimics the ratio within the legislature itself in terms of the committee, but the number of people on the committee could be adjusted. So whereas in the national parliament you may have 9 on a committee or more, in the Tobago context and the 26 members that you have in your assembly legislature, you may end up with 5 or you may end up with 6 or 7. That is something for the assembly men and women to really work out, as long as the ratio of the majority to minority to independent is kept on the joint select committee. So it really isn't affected by the number of executive members that are eventually set up.
Two questions to you through the chair. One, as you speak, the notion of how this thing evolves comes to mind. And very often with any piece of legislation, there comes a time when the thing evolves. One of my fears about this whole process is that is what we codify into law in Trinidad as opposed to in Tobago. Because if you look at the 4th schedule, we don't have powers to necessarily change anything, not in the constitution bill I'm talking about, but the Tobago bill that will not be a constitutional measure. We don't have any authority to deviate from that or to change that or to have that evolve. It means that anytime there is a need for a change, it means just as is the case now with Act 40 of 1996, we have to return to the parliament in Trinidad and hope that the national parliament, the one that we're insisting is for both Trinidad and Tobago, will take it up as a matter of priority. So there isn't room for us to do some of that evolution. And I'm not talking about evolution along the lines of changing the constitution, which naturally will require special majority at the national parliament. I'm talking about on the other document, the Tobago bill. Let's say Tobago evolves and there is a need to make some changes there. It means that we must now revert to Trinidad to have it done. And a question that came to mind as you spoke is about whether or not it was...
Assemblyman, I think we understand that point. Do you have a suggestion, or will you send us a suggestion in relation specifically to that issue? Will you have a suggestion now, or would you want to send a suggestion to the committee in writing?
Well, I will send it in writing, but I could briefly say the gist of it, which is that perhaps what the national parliament should be doing at this stage is to really and truly afford on Tobago certain rights within the framework of autonomy and allow us in Tobago to come meet as an assembly and build out the structure of the governance that we want and decide whether or not we want to have a house with so many appointed members, whether we want a house with only elected members. I think that should be the purview of the THA and not the national parliament saying to us in Tobago, this is what you must have. But I will say...
Let me clarify that. In order for us to move from one stage to the next, it is the Parliament of the Republic of Trinidad and Tobago that has to make this law. It is the Parliament of Trinidad and Tobago that has to make the change to the Constitution, and the Tobago Island Government Bill has to become an act. That is the only mechanism that we have that can bring us to the point where you get the autonomy. So it can't be, as you have said, we have to enact the legislation, and thereafter, depending on how the legislation works and how the Constitution Amendment evolves over time of working the autonomy, there may be changes that need to be made. But in the meantime, whilst we are having this discussion and whilst we are having these consultations, we will prepare as best we can the legislation in such a way as to reflect what the consultations have led us to and what the discussions amongst the members of the Joint Select Committee and with expert opinion have brought us to, and we will take both pieces of legislation to the Parliament of Trinidad and Tobago for debate and then for enactment once it is passed. But the building out and so on, that can only really be done when you work the legislation.
Well, I'll
be looking.
I feel that you may have slightly misunderstood what I pitched. So what I will do is that I will send in writing the details of what I'm pitching, which will reflect in terms of how the bills that you're putting before the Parliament, how they should be framed, that will allow for an autonomous Tobago to be able to evolve naturally subsequently. So I'll send you in greater details so that there won't be any misunderstanding. And
okay,
what I will say next, because I will want Pastor Terence Baines to come in before I give the closing.
You know, Pastor Baines, I can really only give you 5 minutes, and then I have to go back to Assemblyman Augustine to do the closing. Because of course we will have subsequent conversations, but for today's sessions, this is what I can offer.
Noted. Good afternoon, Madam Chair, and good afternoon to the committee and to all viewers. I really just have a question that may appear to be very simplistic, but really needs some clarity in my mind. In the opening statement of the document, when it says that the draft bill confirms the recognition of the equality of status between the island of Tobago and the island of Trinidad within the unitary state of Trinidad and Tobago. Is there a difference in the interpretation of the word equality in the context of Trinidad and Tobago as against Trinidad and Tobago, the sovereign unitary state?
We spoke about that this morning, Pastor Baines, and I think I understand that your team, part of your team, if not the entire team, was on with us, and we've dealt with that. Is there any other issue that you'd like to raise? Okay, Assemblyman Augustine, would you like to raise your bring your closing remarks now?
Sure, I will. I want to close by saying thank you for this opportunity to speak to members of the Joint Select Committee. I want to make it public that we will be holding our own consultations with the people we represent on the island because we need their views. I also want to make it clear that we are bounded by their views, and we will find it our duty to defend and push for their views. As I said at the start, I feel as if these pieces of legislation that are supposed to allow Tobago to build out on its own next door, neighboring, is somehow still forcing us to remain underneath, downstairs. And the bills as they are right now cannot get unwavering support from our side. There will be need for changes, and we will send you in writing those changes that we propose. And as I indicated, those changes will be reflective of the feelings of the people we do represent. Thank you for your work, and I want all of Trinidad to know that for us in Tobago, us wanting autonomy is not us saying that we don't like you or we don't want you in our business. What we are saying is we simply want the right to manage our own business in a way that you too can be proud, so that we can be dignified contributors to the country that is Trinidad and Tobago. And we have always been dignified contributors. And now what we are demanding is that we be recognized as such through these pieces of legislation. Thank you all again, and wish you all the very best.
Thank you very much, Assemblyman Augustine and your team. Let me just reiterate that What we had before us was a particular mandate that came from the Forum of Political Parties, that came as a bill, that came to the cabinet, and that was sent to the parliament in 2018. So we had a certain mandate and a certain parameters within which we had to work. So thank you very much for your participation, and we look forward to getting your submissions in writing. Thank you. We'll have a 5-minute break now, and then we will resume at 3:15.
The Constitution Amendment Tobago Self Government Bill. The proposed revised Constitution Amendment Tobago Self Government Bill will alter the Constitution of Trinidad and Tobago to enshrine into our Constitution certain rights exclusively to the island of Tobago. Tobago will become an autonomous region free to pursue its economic, social, and cultural development within the margins of the Constitution of the Sovereign Unitary State of Trinidad and Tobago. The bill clearly affirms that both islands are equal, none superior to the other. Therefore, any reference to Tobago as a ward of Trinidad is to be removed from all laws or other records wherever it appears. The Constitution will now establish the Tobago Island Government. Staff who work for this government will fall under the umbrella of the Tobago Division of the Public or Teaching Service Commission as proposed by the committee. Also, the Constitution will establish a completely new Tobago legislature with the ability to pass laws for Tobago that will come into effect on assent by the President, similar to the process followed for the enactment of laws by the National Parliament. A companion bill provides workable financial arrangements and sets out incidental but important matters for the operations of the Tobago Island Government and Legislature.
The new Tobago Legislature. The proposed Tobago Legislature will be a unicameral one, comprising of a reformed House of Assembly and the President of the Republic of Trinidad and Tobago. In the Caribbean, there are several examples of legislatures that are unicameral, namely Anguilla, Dominica, Aruba, Nevis Island, Guyana, the British Virgin Islands, St. Vincent and the Grenadines, the Cayman Islands, Curacao, Martinique, Montserrat, the Turks and Caicos Islands, and the U.S. Virgin Islands. The committee carefully studied the advantages of these models and found some to be quite useful to its work. The proposed new Tobago House of Assembly will comprise 15 elected assemblymen, 5 councillors appointed by the President on the advice of the Premier, 3 councillors appointed by the President on the advice of the Minority Leader, 2 councillors appointed by the President in his or her discretion from outstanding persons resident in Tobago, from economic, social, or community organizations or other fields of endeavor, and a presiding officer who may or may not be an assemblyman or a member of the Tobago Executive Council. There is now a provision for the appointment of councillors to temporarily fill vacancies due to illness or absence from the country of appointed members. The Constitution will be amended to empower the members of the new Tobago House of Assembly to make laws for the peace, order, and good government of Tobago, and such laws will be called Tobago Acts. Laws that can affect fundamental rights and freedoms of the citizens of Trinidad and Tobago will remain under the jurisdiction of the National Parliament of Trinidad and Tobago. Also, broad policy issues for which there is the need for the harmonizing of laws will also be the responsibility of the National Parliament. This is to ensure that there is no conflict of laws. The 4th schedule of the Constitution will list the areas for which the Tobago Legislature will have exclusive lawmaking powers for Tobago.
Why is there a need for such schedule? This arrangement is necessary as it promotes the legal certainty that will be required by both the National Parliament of Trinidad and Tobago and the Tobago Legislature when making laws. While some aspect of the functions of this legislature will be in the Constitution, a companion bill provides for operational matters and proposes several oversight committees to be established within the legislature to oversee the work of the Tobago government. Therefore, The new Tobago legislature, unlike other parliamentary bodies, will be lawfully required to fulfill the following roles: lawmaking, scrutiny of the government, representation of the people of Tobago. As is the case at present, the bill proposes that the Tobago legislature will continue for 4 years from the date of its first sitting. However, the bill aims for greater certainty in the calling of a general election for Tobago and proposes that a general election should be held on the second Monday after the date of the 4th anniversary of the last primary election. As a legislature with the power to make laws to affect the lives of its people, the Tobago legislature will finally be able to take a seat at international assemblies where legislators meet regularly to discuss matters related to their roles and functions. So the Tobago legislature will be able to speak for the people of Tobago and leave its mark on the international stage.
The new Tobago government. Clause 11 of the bill amends the Constitution to accord the new Tobago Island government exclusive executive powers to manage all areas listed in the 5th schedule to the Constitution. The Tobago government will be managed by an executive council comprising a premier, a deputy premier, a secretary for legal affairs, and such other secretaries as may be necessary to govern the affairs of Tobago. This new arrangement will deepen Tobago's autonomy. Civil matters involving the Tobago House of Assembly and the Tobago government will now be handled exclusively by the Division of the Secretary for Legal Affairs. As is the case today, the Tobago government, by way of a Memorandum of Understanding arrangement, can be empowered to act on behalf of the government of Trinidad and Tobago in respect of any of its residual responsibilities in Tobago. The Premier for Tobago now has to be consulted before appointments can be made to certain posts like the Chief Administrator, Administrator, Head of a Department in a Division, and Chief Professional Advisor. The proposed amendment to the Constitution will require the President to act in accordance with the advice of the Tobago Executive Council or a Secretary acting under the general authority of the Tobago Executive Council with respect to matters in the exclusive jurisdiction of the Tobago government. This patterns the law related to matters in the exclusive jurisdiction of the central government of Trinidad and Tobago. Should there be conflict of any kind between the government of Trinidad and Tobago and the Tobago Island government, the bill proposes that the parties be legally required to make meaningful efforts to settle matters before any attempt is made to approach the courts.
The financial provisions. The draft companion bill, entitled the Tobago Island Government Bill, proposes financial arrangements for the management of Tobago's funds. The bill proposes that Tobago be appropriated 6.8% of the annual appropriation as a minimum. However, the law further provides for increases over and above this sum on the recommendation of a fiscal review commission. The Tobago government will be empowered to retain all revenues collected on the island. The draft bill proposes that a Tobago fund be established to consist of monies appropriated by the Parliament of Trinidad and Tobago for the use of the Tobago government and such other monies that the Tobago government may lawfully collect, borrow, earn through investments, or be granted. There will also be a contingency fund to provide for unexpected expenditure. The rules or the management of all finances of the Tobago government are required to be debated and approved by the Tobago legislature. No longer will there be the need to send estimates to Trinidad for approval. The Tobago legislature must now also debate and approve its own Tobago Appropriation Act, which, together with detailed estimates, must be laid in the House of Assembly. The members of the Assembly will be required to examine those estimates and seek information from the Executive Council on proposals for expenditure of Tobago's funds. All this will now be part of the new Tobago budget process and is in keeping with the arrangements in legislative bodies the world over. Quite significantly, this bill provides for the establishment in law of the following committees of the Tobago legislature: a Public Accounts Committee, a Public Administration and Appropriations Committee, a number of oversight committees to scrutinize the operations of the Tobago government, What this means is that the expenditure of Tobago's funds will be exclusively decided in Tobago by Tobagonians with oversight by the Tobago legislature, both during and after the budgetary process. The Constitution Amendment Tobago Self Government Bill. The proposed revised Constitution Amendment Tobago Self Government Bill will alter the Constitution of Trinidad and Tobago to enshrine into our Constitution certain rights exclusively to the island of Tobago. Tobago will become an autonomous region free to pursue its economic, social, and cultural development within the margins of the Constitution of the Sovereign Unitary State of Trinidad and Tobago. The bill clearly affirms that both islands are equal, none superior to the other. Therefore, any reference to Tobago as a ward of Trinidad is to be removed from all laws or other records wherever it appears. The Constitution will now establish the Tobago Island Government. Staff who work for this government will fall under the umbrella of the Tobago Division of the Public or Teaching Service Commission as proposed by the committee. Also, the Constitution will establish a completely new Tobago legislature with the ability to pass laws for Tobago that will come into effect on assent by the President, similar to the process followed for the enactment of laws by the National Parliament. A companion bill provides workable financial arrangements and sets out incidental but important matters for the operations of the Tobago Island Government and Legislature.
The new Tobago Legislature. The proposed Tobago Legislature will be a unicameral one, comprising of a reformed House of Assembly and the President of the Republic of Trinidad and Tobago. In the Caribbean, there are several examples of legislatures that are unicameral, namely Anguilla, Dominica, Aruba, Nevis Island, Guyana, the British Virgin Islands, St. Vincent and the Grenadines, the Cayman Islands, Curacao, Martinique, Montserrat, the Turks and Caicos Islands, and the U.S. Virgin Islands. The committee carefully studied the advantages of these models and found some to be quite useful to its work. The proposed new Tobago House of Assembly will comprise 15 elected assemblymen, 5 councillors appointed by the President on the advice of the Premier, 3 councillors appointed by the President on the advice of the Minority Leader, 2 councillors appointed by the President in his or her discretion from outstanding persons resident in Tobago, from economic, social, or community organizations or other fields of endeavor, and a presiding officer who may or may not be an assemblyman or a member of the Tobago Executive Council. There is now a provision for the appointment of councillors to temporarily fill vacancies due to illness or absence from the country of appointed members. The Constitution will be amended to empower the members of the new Tobago House of Assembly to make laws for the peace, order and good government of Tobago, and such laws will be called Tobago Acts. Laws that can affect fundamental rights and freedoms of the citizens of Trinidad and Tobago will remain under the jurisdiction of the National Parliament of Trinidad and Tobago. Also, broad policy issues for which there is the need for the harmonizing of laws will also be the responsibility of the National Parliament. This is to ensure that there is no conflict of laws. The fourth schedule of the Constitution will list the areas for which the Tobago legislature will have exclusive lawmaking powers for Tobago.
Why is there a need for such schedule? This arrangement is necessary as it promotes the legal certainty that will be required by both the National Parliament of Trinidad and Tobago and the Tobago legislature when making laws. While some aspect of the functions of this legislature will be in the Constitution, a companion bill provides for operational matters and proposes several oversight committees to be established within the legislature to oversee the work of the Tobago government. Therefore, the new Tobago legislature, unlike other parliamentary bodies, will be lawfully required to fulfill the following roles: lawmaking, scrutiny of the government, representation of the people of Tobago. As is the case at present, the bill proposes that the Tobago legislature will continue for 4 years from the date of its first sitting. However, the bill aims for greater certainty in the calling of a general election for Tobago and proposes that a general election should be held on the second Monday after the date of the 4th anniversary of the last primary election. As a legislature with the power to make laws to affect the lives of its people, the Tobago legislature will finally be able to take a seat at international assemblies where legislators meet regularly to discuss matters related to their roles and functions. So the Tobago legislature will be able to speak for the people of Tobago and leave its mark on the international stage.
The new Tobago government. Clause 11 of the bill amends the Constitution to accord the new Tobago Island government exclusive executive powers to manage all areas listed in the 5th schedule to the Constitution. The Tobago government will be managed by an executive council comprising a premier, a deputy premier, a secretary for legal affairs, and such other secretaries as may be necessary to govern the affairs of Tobago. This new arrangement will deepen Tobago's autonomy. Civil matters involving the Tobago House of Assembly and the Tobago government will now be handled exclusively by the Division of the Secretary for Legal Affairs. As is the case today, the Tobago government, by way of a Memorandum of Understanding arrangement, can be empowered to act on behalf of the government of Trinidad and Tobago in respect of any of its residual responsibilities in Tobago. The Premier for Tobago now has to be consulted before appointments can be made to certain posts like the Chief Administrator, Administrator, Head of a Department in a Division, and Chief Professional Advisor. The proposed amendment to the Constitution will require the President to act in accordance with the advice of the Tobago Executive Council or a Secretary acting under the general authority of the Tobago Executive Council with respect to matters in the exclusive jurisdiction of the Tobago government. This patterns the law related to matters in the exclusive jurisdiction of the central government of Trinidad and Tobago. Should there be conflict of any kind between the government of Trinidad and Tobago and the Tobago Island government, the bill proposes that the parties be legally required to make meaningful efforts to settle matters before any attempt is made to approach the courts.
The financial provisions. The draft companion bill, entitled the Tobago Island Government Bill, proposes financial arrangements for the management of Tobago's funds. The bill proposes that Tobago be appropriated 6.8% of the annual appropriation as a minimum. However, the law further provides for increases over and above this sum on the recommendation of a Fiscal Review Commission. The Tobago government will be empowered to retain all revenues collected on the island. The draft bill proposes that a Tobago fund be established to consist of monies appropriated by the Parliament of Trinidad and Tobago for the use of the Tobago government and such other monies that the Tobago government may lawfully collect, borrow, earn through investments, or be granted. There will also be a contingency fund to provide for unexpected expenditure. The rules or the management of all finances of the Tobago government are required to be debated and approved by the Tobago legislature. No longer will there be the need to send estimates to Trinidad for approval. The Tobago legislature must now also debate and approve its own Tobago Appropriation Act, which, together with detailed estimates, must be laid in the House of Assembly. The members of the Assembly will be required to examine those estimates and seek information from the Executive Council on proposals for expenditure of Tobago's funds. All this will now be part of the new Tobago budget process and is in keeping with the arrangements in legislative bodies the world over. Quite significantly, this bill provides for the establishment in law of the following committees of the Tobago legislature: a Public Accounts Committee, a Public Administration and Appropriations Committee, a number of oversight committees to scrutinize the operations of the Tobago government. What this means is that the expenditure of Tobago's funds will be exclusively decided in Tobago by Tobagonians with oversight by the Tobago legislature, both during and after the budgetary process. The Constitution Amendment Tobago Self Government Bill. The proposed revised Constitution Amendment to Tobago Self Government Bill will alter the Constitution of Trinidad and Tobago to enshrine into our Constitution certain rights exclusively to the island of Tobago. Tobago will become an autonomous region free to pursue its economic, social, and cultural development within the margins of the Constitution of the Sovereign Unitary State of Trinidad and Tobago. The bill clearly affirms that both islands are equal, none superior to the other. Therefore, any reference to Tobago as a ward of Trinidad is to be removed from all laws or other records wherever it appears. The Constitution will now establish the Tobago Island Government. Staff who work for this government will fall under the umbrella of the Tobago Division of the Public or Teaching Service Commission as proposed by the committee. Also, the Constitution will establish a completely new Tobago legislature with the ability to pass laws for Tobago that will come into effect on assent by the President, similar to the process followed for the enactment of laws by the National Parliament. A companion bill provides